Hey everyone, Harry here to talk about the stunningly brazen and incorrigible Rudy Giuliani, who is under an injunction and has been for a time, quite separate from the remedy for defamation that he has to pony up and we're having this huge fight over. But over a year ago, an injunction was entered saying, Giuliani, do not defame Ruby Freeman and Shay Moss, the Georgia election workers, any longer. He consented to exactly that. And just hot off the presses is a motion for civil contempt. I'll go into that a little bit more, for violation of the injunction by Moss and Freeman. And it's based on a series of statements that Giuliani is making on podcasts that are absolutely, unambiguously repetitions of his defamation. So let me describe some of those for starters. So you have a motion about 6 pages or so that is in the District of Columbia court. This isn't before Lewis Lyman, who is now having to force Giuliani to actually turn over his property to Moss and Freeman. That's because things have gone through different courts and bankruptcies that were then dissolved, and actual motions to attach things in New York where the property is. This is a previous part of the whole litigation mess in which the defamation was tried, and in which, in particular, the injunction was entered, because this is in front of the court that is, in theory, in some way of thinking about it, injured because the court's order enjoining Giuliani, again, which he consented to, is what's been violated, and the court's authority that sort of has been put at issue. Okay, so we're going on for, I think, 4 years now, right? This is stuff that happened in the wake of the last election. 4 years ago is when he launched his defamatory campaign, and we can go on and on and on to the actual finding of defamation, which was preceded by all kinds of contemptuous, I use that in just its vernacular. In other words, not respecting court orders and trying to get out of them, etc., to arrive at the point we're at in turning over property in New York. In the meantime, though, this injunction is still in play, and so Moss and Freeman bring the motion, and they have some quotes just wild. Okay. He's got a nightly show. In one, he claimed that Moss and Freeman never let me show the tapes that show them quadruple counting the ballots. So they quadruple counted the ballots. It's completely false, and it's a repetition of the defamation. You remember the basic defamation where he says there's a suitcase there and it shows them sneaking it out, and that the mishandling of the ballots. So that's the whole false narrative that they testified in Congress completely upended their lives and was what justified the 150 million or so verdict. A fair bit more. The tapes showed the plaintiff passing these little hard drives that we maintain were used to fix the machines. Excuse me? No, the tapes do not show that at all. When you look closely, it was very clear they don't. That's what made this defamatory. He writes, you can see if you want in living color her quadruple counting votes. No, that's a lie, and a defamatory lie, and just a flagrant violation of the injunction. So he's just doing this on his show. I try not to waste time in psychoanalysis of certain figures, and Giuliani is one of them. But is there some incredible bifurcation of mind where he says one thing to court and then just forgets it when he goes on his show? Is he just completely subject to kind of senility? But this is not a remotely close call. And there's more that they sort of spell out his whole kind of campaign. And here's one recently where he's talking about the current litigation with Judge Lyman. Now, if you wanted me to make out a check to pay my bills, I can't do it because of Judge Lyman, apparently didn't remember the name, and Biden people who are behind the case of the two women. Biden's behind the case of Moss and Freeman, and that's why you have all these damages. In fact, there's video of them doing what I said. We can play it for you if you want. I got a chance to show them. They never let me show the tapes that show them quadruple counting the ballots. That very quote is repetitious of what I said before. In other words, it's the same thing, but it's with greater context. But I mean, this is an open and shut case of a violation of injunction. Okay, so let's just start there. Now what happens? So this is the court that entered it, and they've asked for him to be held in contempt. And now we get a little bit into the law of contempt because it's tricky. There are two kinds of contempt. There's criminal contempt, where you knowingly violate an order and you're subject to criminal penalties. But it's got a lot of procedural protections. A case has to be brought. It's not orthodox for a court just to find you're in criminal contempt. Then there's civil contempt, not a criminal penalty, not beyond a reasonable doubt, not with all the constitutional protections. However, the notion of civil contempt is to enforce compliance. The way it's normally put is the defendant holds the key to the jail. One I always think of for this is someone who didn't want to testify during Whitewater, Susan McDougal. They put her in jail until she testified, and she just stayed there for a few years rather than testify. She just did the time. You can't whip them. This is what the legal system can do in order to enforce compliance with a standing order. So Moss and Freeman come into D.C. District Court and say, hold him in civil contempt. A little bit funky, though, because what they're really saying is he's violating it. He should be punished in some way, or at least what may well happen, called on the carpet and slapped around by the judge, metaphorically, of course. And civil contempt is meant to, do compliance. Now, what they are saying is you should impose a fine. And by the way, you should give us lawyers' fees, which we're permitted to get, that is designed to make sure he complies going forward. What does that mean exactly? He's under a strict court order. If in addition they made him pay, and you don't get it back. It would be when you pay a civil contempt fine. It's a fine. Like Trump has been fined before for non-compliance with discovery orders, $10,000, $20,000. That money just is gone. So that would be the notion that Giuliani would part with the money, except it's a little bit tricky to say he's currently every time he does something like this, he's in non-compliance. But is he now in non-compliance, and is a fine calculated to actually put him into compliance, meaning don't do it again? Well, that's the argument. So you have the Shea and Moss submission. First, it goes through. Giuliani has violated the clear and unambiguous terms of the consent injunction. Are they clear and unambiguous? Yes. Did he agree to them? Yes. Has he violated them? Yes. I really think that's an easy lift. He's violated the injunction. But now we come to what happens, and they say you should enter civil contempt sanctions to ensure future compliance. And that's that kind of tricky situation I've said, and they set out the law, but it's law about forcing someone into compliance. And that's much more typically you haven't paid a fine and you need to do it, or you have to testify, you have to do a physical act and you haven't done it. I mean, you can imagine, for example, civil contempt, if it continues to develop that way with Giuliani on not giving up the keys to the storage facility where he may have moved all his possessions to, something like that. But this is a past act, so it doesn't fit very well. But they're saying, look, you should do it anyway. And here's exactly what you should do. Hold him in contempt right now, and then hold a hearing. And during this hearing, you can figure out what should be the right amount of civil contempt fine in order to enforce compliance. Now, I don't know if that's what the court will do, just because it's a hard kind of pay $1 million, which, by the way, you're Giuliani, you're a deadbeat, you don't have. You have to give up what you already do have to Moss and Freeman. So, we're in a sort of blood from a stone posture. But in any event, it just isn't a normal kind of remedy for what is, in essence, a past violation, a clear violation of the injunction, but a past one. So holding in contempt, very possibly, and some kind of hearing and calling on the carpet and, screaming at him and what the hell are you doing and you better not do this further. Also very plausible. Not sure if we'll see civil contempt or not. But the main point here is the publicizing, including in front of the court, of just what a complete incorrigible SOB the former mayor of America is, and how he continues to do exactly what he's been ordered by a court not to do unambiguously, and agreed to the order over a year ago. So just a complete outlaw and a serial violator of all kinds of court orders, discovery, surrender of property, and now, a simple thing like stop defaming them, please. So there'll be some kind of reckoning, I think, but it may not be civil contempt. But stay tuned. In any event, the motion itself and what it chronicles about what he's doing on his nightly show is pretty vivid and illuminating itself. And what it illuminates is a guy who just can't follow the law or give up on his patently false and defamatory statements about these two Georgia election workers. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.